Welcome to the Taxpayer Podcast, a podcast production by the Taxpayer. For more informative discussion on tax law, please visit our website to learn more about the Taxpayer Journal.
Hello, Peter. Nice to see you again.
Hi, Trevor. Hi, Trevor.
It's been a while, hasn't it?
It's been too long.
All sorts of things happening. Can I just say, for the benefit of our viewers and or listeners, what Peter and I are about to discuss is completely unrehearsed. I have no idea what his views are. I don't think he knows what they are. So it's a bit of an experiment all around. But I think that's the way we like to do it. So it's I won't say it's entirely spontaneous, but it certainly is not rehearsed.
Unfiltered, yeah.
So where are we? It's September already. It's crazy how quickly the end of the year is coming. This podcast has been a while in coming, but we're going to talk about the draft tax laws amendment bill. Do you want to kick off, Peter?
I will. Thanks, Trevor. So the draft taxation laws amendment bill, or the TLAB as we call it, was released on 31 July, which is a bit later than normal. Normally comes out in June, but be that as it may. And the next step after it's released is that obviously all of us tax people, read it as thoroughly as we can. And then we need to give comments on it. And those comments had to be in by 31 August. So that date has come and gone. In fact, even after that, we've even had the workshops. So National Treasury run a series of workshops based on the comments that they get. And those workshops happened in the last couple of weeks, and they were quite robust in respect to some of the discussion points, and some of those points we're going to canvass today. And then the next step after that is that Treasury provides a response document to all of the comments that they've got, the submissions and the workshops. And then after that, that's pretty much the end of the process. The bill is then finalized and normally passed at the end of the year. But Trevor, I don't know your sense, but my sense is this is actually a nice process. It's robust. The parties both get involved. Treasury, us as the advisor community can make our submissions. We can have a proper debate, proper discussion. And I think you end up with a much better product than in a lot of countries where legislation is just thrust upon the taxpayers with no advance warning. So we complained about it a lot, but I think the process itself is actually quite healthy. Obviously, it depends to what extent comments are taken on board by Treasury, but the process itself I like.
Yeah, it makes a stark contrast to the Tax Property Control Act, which just came out of nowhere, and the amendments to the tax rules. Not that
tax rules
too startling about that, but they just suddenly appeared.
That's true. I remember we chatted about that. No. So the process I like, as I said, it depends a little bit on how Treasury, how seriously they take the submissions, but it's a good process. And I think the first thing we wanted to chat about is the Section 25B provisions, Trevor, and that, it's linked to the Thistle case. It's not directly linked, but it's sort of aligned to the Thistle case, which I know you have quite strong feelings about. But 25B, the flow-through principle now doesn't apply to non-resident beneficiaries.
Yes, well, the curious thing is that they amended Section 25B previously to exclude capital amounts. And then one of the complaints about the Thistle case is the judge in the Thistle case says that because it was changed to exclude capital amounts, that's an indication that it always excluded capital amounts. And there was no capital gains tax when it was first introduced. And, what we can say now is that the Constitutional Court has granted leave to appeal. Well, the way it's done is you appear in court and then they decide whether to grant leave or not. But the hearing is all done in one go. So that is taking place. And I'm happy to say that I will be a spectator from a distance, not in court. I did appear in the Supreme Court of Appeal, but I shall not be appearing in the Constitutional Court. I have no ambition to appear in that court. 5 judges is enough for me. 11 or 9.
11.
just too much.
I remember you said to me some time ago, Trevor, that the Supreme Court of Appeal got a lot less intimidated when they stopped speaking Latin. I'm misquoting you a little bit, but it was something along those lines. You said in the old days it was pretty terrifying when half of the 5 judges could actually converse in sort of legal Latin. So
those days I
that comment.
Yeah.
Sure.
But seriously, what's going on in the SCA is quite worrying because I have a case that was argued in March, and we're still waiting for judgment. Now, that was unheard of in the past. And the case, the ABSA case, what was argued on the 8th of March, and it's still being awaited. Now, that's very unusual. Previously, there was always pressure to get the judgments out because there were 5 judges involved. You know, it's easy if it's just you on your own to delay things, but with the other judges involved, it's difficult.
And didn't the judgments have to come out at the end of, they were supposed to come out at the end of each term? Isn't that sort of the normal sort of protocol?
No, I think they normally did.
Mm-hmm.
But anyway, just have to be patient. But
it's interesting
it
thing in
seems
terms
to
of
me that, and unfortunately I left my bill at the office, and I'm doing this from home. But what they've done is they've excluded the operation of Section 25B from non-residents. So it only applies if the taxpayer is a resident. Now, they'd already excluded capital amounts. So that means that this confining the provision to, remember what Section 25B does, perhaps just for the benefit of viewers and listeners, to the extent that an amount is received for the immediate or future benefit of an ascertained heir or beneficiary, it's deemed to accrue to that beneficiary, and to the extent that it's not, it's deemed to accrue to the trust. So they already excluded capital. Now they're saying with income, it only applies to residents. And the question that occurs to me is, does that spell the end of the conduit pipe principle as far as income is concerned? Certainly as far as non-residents are concerned, it would seem. Because to the extent that it does not accrue to a beneficiary who is a resident, then it's deemed to accrue to the trust. So that would seem to leave no room for the conduit pipe principle, which saddens me because that was an important part of our law, and it's just being tossed out.
It's an interesting point because
and ironically, it doesn't necessarily affect the conduit pipe principle as far as capital amounts are concerned. I know what the SARS argument would be. SARS's argument would be, well, Section 80 or paragraph 80 of the 8th schedule only applies to residents and not to non-residents. And now they're making Section 80B only apply to residents. But that's premised on the view that in the case of non-residents, it simply accrues to the trust. But if the conduit pipe principle is alive and well in respect of non-residents, as far as capital amounts are concerned, the argument persists. So not all is lost, depending whose side of the fence you're on. I don't know. Do you have any comments on that?
Yeah, I do. I just wanted to make a couple of points on it. One is that the effective date is such that we're already into this provision. So it applies with effect from 31 July, which is when the draft taxation laws amendment bill came out. And so it effectively has retrospective effect, given that it'll only be passed at the end of this year. And that point was made quite strongly in the workshops. And then the other point is that it will lead in many cases to economic double taxation, because as you say, Trevor, the income will flow through to the non-resident beneficiary, quite likely to be taxed in their jurisdiction, depending on their domestic tax laws, because they'll see it as income accruing to that non-resident beneficiary in their jurisdiction. But of course, that income will also be taxed in the hands of the trust in South Africa. And the problem with economic double taxation is that a double tax agreement doesn't cure it, because it's not juridical double taxation. So it'd be hard for the beneficiary to say, hang on, this income's already been taxed, because the foreign jurisdictions, tax authorities will be saying, but not in your hands, in the hands of another legal entity being the trust. And we don't have to provide a tax credit in those circumstances. So I think the economic double taxation prospect is real and has been made, that point was made quite strongly to National Treasury in the workshops. And we'll see how they sort of deal with it. But I think that was one of the reasons for the conduit pipe principle, Trevor, is that the income's only taxed once, and if it's not taxed in South Africa because there's a non-resident beneficiary, then so be it. And if SARS are concerned about tax leakage and tax sort of, going away, for example, if somebody's in a tax haven jurisdiction, then they must deal with that in another way. But I think those were 2 points that were made.
Yeah. So, to some extent, it's still wait and see what the final bill and the final act looks like. But there is cause for concern.
I think that's right, yeah. And I just wanted to touch on
would you agree that as far as capital amounts are concerned, the argument still exists that as far as capital is concerned, the conduit pipe principle has not been turned off?
Well,
who knows how a court can interpret that?
Yeah, it depends a lot, I think, on this whole court judgment and the constitutional court, as you said.
Yeah.
And sort of where that comes out, because the SCA has obviously provided its views on that.
In Thistle, the beneficiaries were all residents. So the issue of non-resident beneficiaries doesn't arise. And of course, those facts were way back in, I think, 2016. So these new amendments also ought not to apply, although that didn't seem to filter through to Judge Hughes in the SCA. But I can say that there are other cases in the wings where there are non-resident beneficiaries, also looking back. So the conduit pipe principle is likely to be tested there.
Just moving on to section 9D, and we talked about the coronation case in a previous podcast. And now there are proposed legislative amendments to section 9D arising from the coronation case, which was quite interesting because SARS actually won the coronation case in the Supreme Court of Appeal. And similarly, Trevor, that is also now going to the Constitutional Court. And so, which is good news for the taxpayer, good news for coronation, I think good news generally. And it's interesting how the Constitutional Court is taking on a lot of tax cases, this whole coronation, and there've been some others as well. So it's exercising its jurisdiction in relation to tax cases, which I think is good, especially where they are such important and so important sort of in terms of public interest. But
the case that is going there is the Capitec VAT case, and I wasn't involved in that case at all, nor all I've done is read and comment on the judgment. But somebody who was involved in the background and who virtually, in other words, by video, attended the SCA hearing and was present in the Constitutional Court hearing, which has already taken place. For what it's worth, this person's impression was that the SCA didn't get to square one. They just missed the whole point of the case, which kind of squares with my feelings about it. Whereas the Constitutional Court did. They got the issues, they saw the real points. Who knows what the outcome is going to be, but it's likely to be a meaningful judgment.
So in terms of section 9D, the first point is whether you have a controlled foreign company. And as we know, that occurs in circumstances where South Africans hold more than 50% of the interest in that foreign company. And then an amount equal to the net income of the controlled foreign company is then allocated to the South African resident shareholders, unless it qualifies for the foreign business establishment exemption. So the question is, what is a foreign business establishment? And that's a long definition, but it basically is a fixed place of business used by the controlled foreign company for the purpose of carrying on its business. And one of the requirements is, I'm just going to read this one, that it must be suitably staffed with on-site managerial and operational employees who conduct the primary operations of that business. And that was in respect to the coronation case. They argued that although they had an outsourced model, in other words, coronation outsourced certain functions such as investment management, its employees conducted the primary operations of the business because the business did not include the functions that had been outsourced, which I think makes perfect sense. But coronation lost in the Supreme Court of Appeal, and now the 9D requirements for a foreign business establishment are being changed, and they're changing in particular these words that I've just read out to instead use the words that the employees must perform all the important functions of the business for which the controlled foreign company is compensated. And I think there are a couple of issues there, Trevor, that I'm sort of concerned about in terms of that wording. First of all, the words important functions are very loose. Primary operations, one can sort of understand as a legal matter, but what are important functions? Who's going to decide what's important and what's not? And how does one rank the importance of functions of a business? And then also, they look at for which the controlled foreign company is compensated. And it's interesting whether compensation is sort of a gross concept or a net concept, because if it's a net concept, if you say, well, I'm compensated in relation to the net revenues that I make after I have paid other people, for example, outsourced service providers, then the law doesn't achieve anything. In fact, it kind of confirms the coronation view of the world. So I think it's just a slightly untidy sort of proposed amendment, and I don't like the looseness of the word, in particular these important functions. As I say, that's very open to interpretation, and it's sort of binary, because if you subcontract certain important functions from the controlled foreign company to another third-party service provider in another jurisdiction, you're not going to qualify for the foreign business establishment exemption. So it's a critical decision path, in terms of what's an important function or not. And if you have outsourced an important function, then, as I said, the exemption simply doesn't apply, which is quite draconian, I think.
One aspect that wasn't, so that I can recall, considered by the SCA in the coronation case there's an old Rhodesian decision, Shine, S-H-E-I-N, which dealt with a person who administered a shop or a store in what was then Bechuanaland, now Botswana, and over time spent more and more time in Rhodesia, now Zimbabwe, and did it remotely. And the court said, no, the person accepted responsibility for what happened in Botswana, and that took place in Botswana. Now, if you apply that to outsourcing, one of the important functions is, you might outsource certain tasks, but if you accept responsibility for what is done, that's something that should be taken into account.
I agree.
What weight should be given is another matter. But
the coronation argument was simply, we can outsource certain functions, but we still manage the outsourced service provider. That's our job. That's what we do. Those are our primary operations.
And presumably take responsibility for them.
Exactly. In fact, sure. That would be an important responsibility, is to make sure that they're performing their functions, and you review what they do. And if they're not doing a good job, you fire them and you find someone else. So, and those are your important functions. So, it's getting messy.
It sounds like it's a bit vague.
Very vague. But I go back to my earlier point. It's a good process, and that point was made to National Treasury, and let's see if they come up with sort of more refined wording, or just don't change it. Don't change it. So it'll be interesting to see what comes back in the response document there.
And then the other,
Section 11.
The other provision is the substitute for practice note 31.
Exactly, yeah.
That's section 11G, capital G. Sorry, I don't have it in front of me. I've left it behind. But it's making it compulsory for companies that lend money in order to earn interest from group companies. They can deduct that, but only to the extent of the interest that is incurred. using borrowed money. Is that right?
Quite restricted, because as you say, 11G proposes that a company can deduct expenditure that's not of a capital nature. That's fine. That's incurred by the company in the production of its income. That's fine. To the extent that the expenditure is incurred in the production of interest income, and here come the problematic words, from another group company. So it only applies if you are looking to deduct expenditure, typically interest expenditure, in relation to a loan that you've advanced to another group company. That's very narrow. I mean, that really is narrow, and it only applies to companies. So it doesn't apply to trusts, individuals, etc. And it only applies in a group context. So it's a very narrow carve out that the Treasury are sort of looking to achieve. And that certainly doesn't replace Practice Note 31, which was much wider.
And the premise of Section 31 of Practice Note 31 was that the company was not trading. And so therefore nothing was deductible, but they would allow the deduction to the extent of interest income.
Exactly, yeah.
With this provision now, what if the company is trading? I've got a decision that was argued in Johannesburg about 2 months ago. We're still waiting for judgment, and it's on exactly that issue. And we argued that the Practice Note 31 spoke about having to be a money lender in order to be trading. Now that's nonsense. The money lender test is only relevant where you've got a loss of capital, if a loan becomes irrecoverable. But where all you're doing is trying to deduct the interest, you don't need to be a money lender. You simply have to be carrying on a trade. So if a company falls within the new section 11G, and it is trading, would it have to deduct under that provision? I'm just looking.
I think you'd say 11G just doesn't apply. If it's certainly if it doesn't qualify. In other words, if it's not to a group company, 11G just wouldn't apply, and then you'd be under 11A, 24J. If 11G did apply, then I think it would apply, Trevor, and the trade requirement is just not necessary, I guess.
One must bear in mind Section 23, capital B, subsection 3, which says, no deduction shall be allowed under Section 11A in respect of any expenditure or loss of a type for which a deduction or allowance may be granted under any other provision of this Act. So the danger is, you might have not qualified under 11 capital G, but you might have qualified under 11A. But does the effect of 23B3 now exclude you from 11A and force you into 23G? I don't know.
Another interesting thing is the trade requirement, and I think we chatted about this because Practice Note 31 talks about where a company's got surplus capital that it earns interest on. But if you're in the business of advancing loans, and as you know, Trevor, trade is very widely defined and widely construed, and that's to SARS's advantage generally to show that you're carrying on a trade, that it doesn't take much for a company to say, you know what, I actually am carrying on a trade, because it's not completely passive income. It's not just surplus income that I've got in some bank account. I'm actually advancing loans, and that's part of a trade. As you say, I'm not saying I'm a money lender. I'm just saying I'm carrying on a trade. Then your interest is deductible. And I think people need to look a lot more carefully at whether or not the trade requirement is in fact met. Because a lot of clients are panicking and they're saying, we've got back-to-back loans, we've got like 5 different companies all lending to each other. None of them are group companies. And this results in triple, quadruple tax because you tax on a gross basis, no deduction all the way through the chain. And I'm saying, but hang on, let's look at the trade requirement and just see if it is met, because it is a wide requirement. It is a wide test, and it's quite easy to fall into, or to show that you are carrying on a trade. Single venture can be a trade, etc.
Yeah, and the Tiger Oats case is a very useful case there, because although that was the regional establishment levy, it still dealt with whether they were trading or not.
That's true.
Yeah, and the case where I'm waiting for judgment, SARS had pleaded that the taxpayer was trading as a holding and investment company. And we said, forget about the investment side of it. it's normal for holding companies to advance loans to their subsidiaries at low interest, because they are the holding company. They'll reap the rewards from that, and we'll see what the court has to say about
it. That tax court, Trevor.
Yes, it's the tax court. No, sorry, it's a tax case in the High Court on appeal from the tax court. The tax court held that they failed the money lender test, but we never argued the money lender test. So we said the tax court got it all wrong. Context is everything. In the context of only just deducting interest, you don't have to be a money lender. So that test is irrelevant. And SARS had in fact said they are trading as a holding company. And so then the question was simply whether that interest was incurred in the production of income. And we said it was. So we'll see.
This provision is supposed to take effect.
The point that you raise about a number of interlinking companies, and they're not group companies, and if you get taxed on the income and not allowed a deduction, it could be catastrophic.
Catastrophic is exactly the word. And that's quite often the case in these financing transactions, that you have back-to-back loans and you have lots of security SPVs and you have lots of entities in a chain, and you just have interest flowing through and there's no mischief. And I think that's the mystifying thing, is that this arises from some mischief in the market. And instead of identifying the mischief and dealing with it, you throw the baby out with the bathwater and take away practice note 31, which has worked pretty well since October 1994. So I think the approach is just
this case where I'm waiting for judgment, the tax court actually suggested that there was mischief involved, because we're trying to deduct certain things which are in truth in the production of capital profits. And I tried to make the point in the appeal, what they're forgetting about is that interest that the company is wanting to deduct is taxable in the hands of the person who receives it or to whom it accrues. So there's no mischief.
Tax symmetry.
Yeah, exactly.
Deduction and taxation.
Yeah, it's the right word. So what all of this suggests is that there are things in the melting pot at the moment.
Lots of interesting stuff going on. I think the other interesting deduction was this 12BA deduction, which is 125% in relation to machinery, plant, equipment, etc., used to generate, you guessed it, electricity. Bit short of that. And so it's a high incentive, 125%. And it's only available for 2 years. So gone. Starting, in fact, it's retrospective. It starts for equipment from 1 March 2023 up until 1 March 2025. So it's a 2-year window. And the taxpayer needs to own the equipment, needs to be new and unused, brought into use for the first time by the taxpayer, or in terms of an operating lease to the lessee. Or if it's not an operating lease, that's okay, as long as the lessee carries on the trade and earns income, back to our point about tax symmetry. So quite a nice new deduction. As I say, a big deduction. Hopefully will help generate some electricity. We've seen a lot of interest from clients and from the funding market, the capital markets as well, sort of getting funds together to try and provide funding for these kind of projects.
There's a real need for that.
The real need for that, absolutely. And it's quite nice that it's short term, so people are sort of jumping in. And then there is a recoupment. So if you do sell the asset by, I think it's March 2026, then there's a recoupment of 20% of your deduction, plus your 8.4A recoupments as well. But to get an upfront deduction of 125%, I think is very, very attractive. And, you know, that's got to be welcomed.
Yeah. Yeah, so they're on the go.
Yeah, the National Treasury is giving and they are taking away in the same bill.
Indeed.
So,
where are we now? Middle of September, or 2/3 of the way through September. I'm sure we can get another podcast in before the end of the year.
Yeah, definitely, at least one.
Yeah.
And we can update viewers on these matters as well, because you're going to get the response document from Treasury should be in October, I guess, so probably in about a month's time. It'll be good to.
There'll be a final bill before. I mean, the act will probably only be promulgated next year. Is that right?
Beginning of next year, when you're all on
Have
holiday.
a final bill before then. Yeah.
We will see it before then. So it'll be good to update everyone by then as well.
Yeah.
So that sounds good.
And I know if you've read your emails lately, you'll know this, but our listeners and viewers won't. We've got a bumper edition of the Taxpayer about to come out, dealing with all these cases where people approach the High Court and the application of Section 105. Again, I've no idea what your views on that are, but it certainly is a hot issue at the moment.
I was involved in 2 of those cases, and both of them went against us in the Cape High Court and in Pretoria as well. So I think that could be our next podcast, Trevor, because it's a very, very interesting topical topic.
Yeah, well, I've I think been fairly outspoken in the editorial, and I asked our co-editor Dennis Davis for his views, both as an academic as a judge. And he has submitted something which I haven't had time to read yet, but he tells me he disagrees with me. So there's room for some healthy debate.
That is good.
I really think that judges have let the side down. You know, they've held that there has to be exceptional circumstances before the High Court will grant its permission for the matter to be heard in the High Court. But that wording is not to be found in Section 105. And, you know, anyway, let's not prejudge the whole thing. But what they seem to have lost sight of is the fact that it was held by Crichton in the Metcash case that there's what he called a strong presumption that against the ouster of the inherent jurisdiction of the High Court. Now, obviously, you have to apply Section 105 of the Tax Administration Act. But the question is, how do you apply it? And where there's a strong presumption, and a presumption is a rule of law which exists side by side with every statute, then you must be cautious about encroaching on the jurisdiction of the High Court by the manner in which you interpret Section 105. And I think the courts have lost sight of that.
And unlike Sutherland's judgment in the Emslie case, I thought he was very good and very clear, and I thought that was a good judgment. And that's why we need the SCA to kind of tell us what they think about the Emslie case. You know, we need to hear it from them.
Well, I think with all these other cases, and ABSA still waiting, gathering dust in some pigeonhole in Bloemfontein, it must end up in the Constitutional Court as well.
That is true. That's a good point. And the sooner we get there, the better, I think.
Absolutely, yeah. And you know, one can be confident that in the Constitutional Court, the courts will actually bear the Constitution in mind in dealing with the issue, because, you know, it may be straying from the topic a little bit, but all other parties in South Africa can have an issue, can present a case, can take something on review on purely administrative law grounds. In other words, the merits don't have to count. If you've been prejudiced by the administrative law aspect, you can have it set aside. Except taxpayers. They've got to go to the tax court, where the merits are, of course, in issue as well. And does that not fall foul of Section 33 of the Constitution, which guarantees the right to administrative fairness for all taxpayers, for all people? Anyway. We could have a whole
discuss it next time, Trevor. But nice chatting to you, and yeah, I look forward to the next one.
Absolutely. Yeah.
Thanks a lot. Thanks, Trevor. Yeah. Cheers. Cheers. Bye.
The Taxpayer is hosted by the editors of the Taxpayer Journal, Trevor, Emslie, and Peter Dachs. For more information on our journal and other products, please visit our website at taxpayer.co.za. Each of our episodes is CPD certified. To claim your CPD points, please visit our website. Thank you for listening to the Taxpayer Podcast. You can find more episodes on your favorite podcast platform or on our website at taxpayer.co.za. Please like and subscribe on YouTube and rate our podcast on your podcast platform of choice.